Welcome, everybody. Welcome to a very interesting day here at the University of Strathclyde. We have the pleasure and the honor of having an eminent speaker with us, Salman M.A, who will be giving the first talk of the day, a very intense day here at the law school. A few words about our speaker, and I will then ask two colleagues to say a few words about the logistics of today and the organization and the government that's supporting us. But first of all, let me say, before I go into details of what Salman M.A has done and so forth, which hopefully won't take me too long, but it could, let me just say that one of the great things of today is that we have the opportunity to listen from somebody who happy to say contributed and shaped to international law, in this field to international water law, and can tell us international water law and the topic he's going to talk to us today from the inside. We had this very lucky situation the last seminar with Kati Kulovesi talking about climate change, and we have it today with water. So Salman M.A had his LLB at the University of Khartoum. He then followed his studies at Yale with an LLM and an JSD. He then started working at the University of Khartoum Law School, first as a lecturer and then as a senior lecturer. Then he did a change in career and started working in the UN family, if I'm not mistaken. So at IFAD in Rome. But after IFAD Rome, he then moved to Washington and started working for the World Bank. At the World Bank, after the Rio Summit in 1994, he became the World Bank's water law and policy advisor. And there will be, I'm sure, a lot of interesting inside stories, both today and this afternoon, from the very interesting experience that Salman and his team has developed working at the World Bank. In 2009, if I'm not mistaken, Salman retired from the World Bank and now has two main activities. He's a fellow of the International Water Resources Association. He'll be one of the eminent speakers at the World Water Congress that will take place next week in Edinburgh. And he's the editor-in-chief of the International Water Law Journal, which is published by Brill. And you may, Salman, say a few more words about the journal, but it is a very interesting new kind of journal. So, as I said, having Salman M.A with us for the audience, for the people online, is a true pleasure and an honor. But before I give the floor to Salman, let me kindly ask our colleague and hydronation scholar Juan Carlos Sanchez to come to the floor just briefly and thank with me the Scottish Government for the kind support that it has provided us for this event.
Thank you, Francesco. Good morning, everyone. For me, it's a pleasure to be here. First of all, because of the prominent speakers that we have today. I have been working personally on international water law, I believe, for 5-7 years. And today I have the luck to hear two of the persons that have in a way shaped the career of young professionals at this time. So it's an honor to listen from Salman M.A and later on from Professor Eckstein, who's also going to give us a lecture. Just a short word about the Hydronations program. So Hydronations, it's a strategy of the Scottish Government which aims to promote at an international level the experiences and the good practices that are being done here in Scotland regarding to water governance. It has a branch dedicated for capacity building, in which Hydronations scholarship for PhDs is one of the branches, and I'm one of those scholars. Right now we are in the third generation, so to say, of this program, and so far there are 17 scholars from all around the world. So I would just would like to invite you also to take a look at those opportunities, because slowly we are building also a network of international people that are working not only on legal issues but also on technologies, also on science, also on economies, incentives, etc. So it's building expertise around water governance, but from different entry points, and somehow taking some of the lessons learned from Scotland, bringing them into other places of the world, and also Scotland is learning at the same time from our experiences back home. So yeah, I will just leave it to that. Thank you everyone. I think we have a very exciting program, so let's hope that it's a very interesting day. Thank you, Francesco.
You're welcome, and thanks also from myself, from the Strathclyde Centre for Environmental Law and Governance, to the Scottish Government. Just one more piece of information, and then I will give the floor to Salman. This is an activity that is also live online, and we want to make it as interactive as possible. So can I ask our researcher at the center, Stephanie Hawkins, to come up, and she will clarify to both us in the room and the people online how we can make this discussion even more lively.
Thank you. As Francesco said, we want to make this as interactive as possible. So those in the room and online, if you have access to Twitter and you want to tweet throughout, I invite you to join the conversation and use the hashtag SCELGwater15. And it should be an interesting session. Thank you.
So for those who are more Twitter friendly, I am not, but those who are more Twitter friendly, please go on and tweet and make it an even livelier conversation. Without further ado, I give the floor to Salman.
Good morning, everybody, and thank you very much for coming for this first session of the event. I'd like to, at the outset, to thank the Scottish Government for making it possible for me to come to Strathclyde University and also to attend the IWRA conference, and to extend heartfelt thanks to Strathclyde Law School for inviting me to be here this morning for this event. It's really a great honor and a pleasure, and I'm grateful for that. Francesco mentioned something about what I'm currently doing, and part of it is being a fellow with the International Water Resources Association, and the second part is being the editor-in-chief of a new journal which Brill has decided to publish, called International Water Law. And it will be a different kind of journal. When Brill approached me and asked me if I could take the chief editor position, I was hesitant. I think I thought there were so many other journals. There is Water International, there is Water Policy, the International Journal of Water Resource Development. Those are 3 dedicated journals to water law. So what are we going to compete with them? And I said, I can't do it because I'm a member of the board of Water International. So there will be a conflict. I said, no, it's different. It's a different creature, and we'll talk to you. So I flew to Boston and sat in their office, their U.S. office, and it is a journal that will publish 4 times a year, like most journals, but each issue will be dedicated to a single article, just one article, in 20,000 to 50,000, 30,000 to 50,000 words, and the whole idea came from the notion that those kind of reports or research products are too short for a book and too long for an article. And so I thought the idea was really great and should be sold on that basis, that this is so that when we speak to our colleagues at the other journals, we tell them that no, we're not competing with you. Actually, we are complementing your work. If we get short articles, we send them to you. If you get long articles, send them to us. And fortunately enough, this was agreed to and accepted by the editors in the other 3 journals. So if you go into Brill's website, you'll find something about the Brill research perspectives, and then there are a number of journals. This was the first one that was the whole concept was developed through it. The length of the article, the author guidelines, the review process, the publication process, and so it was replicated with the other journals that are now in the field. They're being thought about and planned. And actually, it's interesting to see the link between my topic today, entry into force of the UN Watercourses Convention, and the journal, because Brill decided to publish the journal immediately after the entry of the force of the UN Watercourses Convention. they thought and realized that this is the opportune time, this is a high time now that we have a convention dedicated to international water courses. We might as well have a journal dedicated exclusively to international water law. And I think the linkages is really very interesting. And so it's interesting to know the link between the two of them. So this will take me now to our topic this morning, entry into force of the UN Watercourses Convention. Why should it matter? Do I need to use this? I can talk in a loud voice. I don't need it, yeah. I think my voice is higher than the microphone. Well, at least I hope so. Entry into force of the UN, why should it matter? And this is what I plan to do this morning. And what the objective is to give an overview of the evolution and context of international water law, how did we get to where we are now, and outline the preparatory work for the United Nations Convention on the law of the non-navigation use of international watercourses. This is the official name, United Nations Convention on the law of the non-navigation use of international watercourses. A very long title. That's why there is almost a unanimous agreement that we call it the UN Watercourses Convention. 3 words, which are easier to remember and easier to utter. And then present the main areas addressed by the convention, and then its contribution, and then they answer the question that's posed in the title: why should its entry into force really matter? Definition of international water courses: surface and ground waters shared by 2 or more states. Very simple definition when it comes to the words, but very difficult when it comes to putting into effect and practice, as we'll see now and in the afternoon when Gabriel speaks about transboundary groundwater. What are the uses? The thing that jumps to our mind when we speak about international water courses is dams and irrigation and hydropower and all the conflicts of the uses. But there are, those are really the main uses, but there are other uses as well. And some of them are, well, at least one of them is more contentious, where there's more disputes than the non-navigation uses, and that is the boundaries between states. As we'll see in a minute, that boundaries between states mostly are, not mostly, but many are drawn through rivers or lakes. And the question is, becomes, where do we draw the boundary? It may be simple, there may be, and most of them there are treaties. But then when it comes to interpreting the treaty and drawing the line on water, not on earth, that becomes a very difficult and complex issue. So the boundaries between states, then the navigational uses. And interestingly enough, this is historically the most important element of the uses of international water courses, the navigation. That was before the technology developed and kind of sidelined, or the navigation uses. And then there are the non-navigation uses. But we have to distinguish between surface and groundwater. Obviously, we are talking about international waters, we're talking about both, but we can't talk about groundwaters when we talk about navigation or drawing boundaries, but this is only surface water. But there are other problems and other issues associated with groundwater. So let me talk about the first part, and very briefly about the uses of international water courses as boundaries. Boundaries are generally drawn by treaties. So we'll see that in all the cases that went to international tribunals, the issue was a treaty, issue of interpretation of that treaty. But then those treaties have set different theories about where to draw the boundaries. One of them is the Thalweg, a German word for the deepest points of the river, the points that follows the navigation. The navigation, when navigation, you follow the deepest points because they are the ones that have the swift currents and the easier way to move around. So the Thalweg are the deepest points. Then the other point, the other notion is the middle point of the river. Rather than the deepest point, it could be the middle point. And middle points and deepest points are not necessarily, they do not necessarily fall in the same area. You could have a deepest point closer to a left or the right bank, but the middle point is in the middle of the river. And then you have a fourth theory, one of the banks of the river. So the boundaries would be one of the banks, and the river would entirely belong to the other state. And this is not a theoretical, hypothetical case. We have the San Juan River between Nicaragua and Costa Rica, where the river belongs to Nicaragua, and according to the treaty. But then Costa Rica wants some rights to use the water. And also, you had a case in the USA between state of Maryland and Virginia on the Potomac River. According to one treaty, the river belongs to Maryland. It was given as a gift by Queen Victoria to Maryland, Queen Mary, and then the Virginia challenged that, and the Supreme Court said, well, a treaty is a treaty, but Virginia would have some rights over the river, but the river, at least from a legal point of view, belongs totally to Maryland. So it's not a theoretical hypothetical case. And then the fourth case is the river as a condominium, meaning that the whole river belongs to the two states, and they just share it in navigation and non-navigational uses. But those are easy to say. In practice, rivers and lakes change their courses. The drought and floods, and emergence and disappearance of islands, and as we see in one case. So it's really becomes more complex with time and more difficult and challenging with all those droughts and floods and change of the course of the river and the appearance and disappearance of islands. This is just a quick the question of the river being boundaries. Here we look at the Mauritania and Senegal. The entire border is a Senegal River between Mauritania and Senegal. And they had a dispute for a long time as to where the boundaries really belong, but they managed to settle it or at least keep it in abeyance. Then we have the Congo River between the Democratic Republic of Congo and the Republic of Congo. The entire border is the entire boundary. We have Tanzania and Zambia, the Zambezi River. We have the Sobat River between Ethiopia and South Sudan. We have the Niger River between Niger and Benin. So, and then you have the Lake Victoria, which we'll see in a minute. And so there are, this is just an example. I don't want to go through the rest of the world, but we'll go through them. And just it shows that the entire boundaries. And down there is Namibia and South Africa. The entire border between Namibia and South Africa is drawn across the Orange River. And there is a major, major dispute brewing in that area. And interesting enough, we have more cases that have gone to the International Court of Justice on the issues of boundaries than in the issue of non-navigational uses or navigational uses. The first case was between Namibia and Botswana. An island appeared on the Chobe River. The Chobe River is one of the tributaries of the Zambezi River. And then both of them claimed that island. And the question becomes, where are the boundaries? There was a treaty that was signed between Germany and UK, and the question was interpreting the treaty. I was involved in that dispute because the World Bank intervened and offered its good offices. And the two parties came to the World Bank. We spent about a week talking about the different options. And the World Bank suggested managing and administering the island as a condominium between the two countries. Just administer it as belonging to both of you, have a separate legal entity composed of the two countries which would run the island. And basically a tourist attraction. It became a tourist attraction. And there was a lot of income being generated from tourism. They discussed the issue between themselves, and then the last day, Namibia told us that they have contacted the government of Namibia, and Namibia has, the government has turned down that proposal from the World Bank. Botswana accepted it, and then so they went back, and then they decided later on to go to the ICJ. And that was the first case to go to the International Court of Justice on the issues of international rivers as boundaries. And interestingly enough, Botswana won the case. The ICJ decided that reading the treaty carefully, the treaty followed the Thalwick theory, and the Thalwick theory puts the island within the boundaries of Botswana. And Namibia, who turned down our proposal for a condominium administration and management of the island, lost. But the ICJ sweetened that part for Namibia by giving Namibia certain rights on the island, but the entire right, the island legally belongs according to that decision to Botswana. The second case was Nigeria, Cameroon around Lake Chad. Also it went to ICJ. I think we won't have time to go through all of those cases. And then the third case was Burkina Faso and Niger, or the Mercou River on the Niger River. The fourth case was the Niger-Benin over the Niger River. And the fifth case, and the case that's still going on, is between Nicaragua and Costa Rica on the San Juan River. It went about 4 times. Fourth time. They went back and forth, and there is a treaty, an interpretation of a treaty to whom the river belongs, and it's still going on. There are other disputes that are really brewing. There is the Mekong River dispute between Thailand and Lao People's Democratic Republic. The Mekong again changed its course, and at one point Thailand claimed that the river has really moved into its territory, and that not part of the entire river falls within Thailand, and certain area that's no longer a boundary river. And that's this is again brewing. It could end up in the International Court of Justice. There is another dispute between Orange River and South Africa and Namibia. As I mentioned, the river constitutes the entire border between the two countries, and it got complicated. When Namibia became independent and issued their constitution, they said their southern borders run across the middle point of the Orange River. South Africa said, no, no. The entire river belongs to South Africa according to a treaty between South Africa and Germany. So this dispute is there, and it could erupt anytime, especially there were some pronouncement in the last couple of months about fisheries and about Namibia withdrawing a lot of water from the river. So it may end up going to ICJ or the PCA. Another case, third case that may blow up any time is the Meginino Island in Lake Victoria. And this is the border between, Lake Victoria falls between, it's shared by three countries, Tanzania, Kenya, and Uganda. Tanzania has the lion's share, about 49% of the lake. Uganda has 45%. And Kenya has a small portion, about 6% of the lake. But there is an island somewhere here popped up. And it became a tourist attraction. It becomes a nightlife for both countries. And both of them are claiming the island. And the dispute is also, it could erupt any minute. So we do have problems with the boundaries, with international watercourses as boundaries, whether rivers or lakes, and they are in the rise, and they are, as I said, more cases actually before international tribunals than navigation or non-navigational uses. The second use is the navigational use. This is the earliest, the oldest, and the cheapest of all the uses, of three uses. It was used in 17th, 18th, and beginning of the 19th century, ferrying people and goods on boats and steamers within and across the country, within the same country or across the countries, particularly in Europe. And there were treaties adopted for dealing with navigation. The Act of the Congress of Vienna, 1815, was the first treaty ever to be concluded dealing with international watercourses. And then it was followed by, that treaty established the right of navigational for all the riparian countries on reciprocal basis. You allow me, I allow you. And then it was followed in 1885 by the Act of Congress of Berlin, which opened the Niger and the Congo rivers for the European explorers and colonialism. So any country can use the Niger, and any country can use the Congo River to go inside Africa. And actually, one of the most interesting things is that I read a couple of articles recently, serious, by some Egyptian lawyers saying that they can take waters from the Congo River to the Nile River, because the Congo River is an international river according to the 1885 treaty. So you can take water from here across South Sudan and replenish and feed the Nile River. The Congo River is 17 times the water of the Nile River. So if you get 1% of the Congo River, that's almost about the size of the waters of the. And so they were quoting the 1885 treaty. That this is an international river in the sense of it's owned by the whole international community. And of course, nobody will accept that argument. And then there is the Barcelona Convention of 1921. But the customary international law on navigation really establishes the freedom of navigation for states sharing the river or lake on reciprocal basis. Basically, the 1815 Act of Congress of Vienna. But the most important part is that navigational uses have lost their importance because of the change in modes of ferrying people and goods across the country and across countries, and because of the new modes. So it's no longer, we don't have any cases. Are you aware of any cases navigational before peace? I haven't seen any cases. There were some time ago on the Danube, but that was the Oder River, which the International Permanent Court of International Justice, I think 1840 something, where it said that the tributary of an international river is part of the international river and it's open for navigation according to the treaty. So and that takes us to our topic of today, the non-navigational uses. And we have irrigation, the largest user, 75 to 80% worldwide. And in developing countries, it could reach as high as 85, 86%. Countries like India, 85% of the water is used for irrigation. And so that's the largest user of water resources. Hydropower generation, and that brings us the issues of dams and all the debate and the contentious issues. Domestic and municipal uses, industrial uses, whether for cooling or for as dumping for the industrial for dumping waste, industrial waste, sewage, agricultural runoff, the waste dumping, and then we have the natural resources, fisheries, methane gas, and other natural resources, minerals, and of course there is the issue of biodiversity and ecosystem protection and how much water should be left, and the debate that's going on between the environmentalists and the others on how much water should be allocated and left for biodiversity. And there are religious activities, and if we just keep in mind the Ganges River, which would have millions of visitors in one certain day every number of years, and the amount of pollution that could result from that pilgrimage of 50, 60, 70, 100 million people using the river for religious activities. And then there are recreation activities, which we have everywhere. So we have multi-dimensional uses of rivers and lakes. And this is just a few examples of some of them. And of course, with all those uses, there are multiple of challenges. The most important is the steady increase in population from 1.6 to 6.1 during last century. When the last century started, population was 1900. It was 1.6 billion. With the 2000 became 6.1 billion. The figures just got reversed. And you have to remember this rise in population and this increase in population would use the same amount of water. It's just the water, it goes through the cycle, falling from rain, running off, evaporating, getting into rivers and lakes, evaporating again and coming as rain. So we have the same amount of water that we ever had, and we will always have. And with the rise of population, in this huge amount, this is a major challenge. By 2015, now we have 7.4 billion, and we'll get to 9 billion by 2050. Some people are challenging that. They said that we'll probably get to 2050 to 9 billion before 2050. Of course, there is the other challenges: urbanization, industrialization, and climate change, which is a major floods and droughts, major problem. Water coming at the wrong time and the wrong place, a lot of water. Environmental degradation, what's happening around many of the rivers, especially my own country, the Nile, where the desert is moving south at an alarming speed. And the temporal and spatial variations, lots of water coming. 2-3 months of the year, 90% of the water in the fall, and then the rest of the year there isn't enough water. And the poor management, I think this is a major issue. The poor management, and particularly the issue of pricing. Water is viewed as a God-given resource, which states should not charge. And that's a major challenge in many civilizations, Islamic and Hinduism, and other religions, and local religions in Africa. The government has no right to charge for water. This is a God-given resource. And then you have all the problems and in some countries, some of the studies that we did in the World Bank, the pricing system is so distorted that the government ends up, particularly in some states in India, paying the employees who collect the water charges more than they collect. And this is leaving alone the issue of operation and maintenance of the irrigation system. So it's the poor pricing is really become, if you are not paying for water, then what incentives do we have to manage it properly and use it in a more efficient way? And then the large number of international watercourses. We saw this. This is the projected population we have talked about from up to 2050, where it gets to 9 billion. And the other things are the urban-rural. I think that's a major issue because rural population tend to use less water than the urban with all the uses in the cities. Some studies suggested that the use is 30 to 70. A person who is in the rural area would use about 30% of the water that is used by the urban dwellers. And so the movement now is towards urban, and by 2010, the rural and urban population of the world were really equal. And now the trend is moving towards urban, a very challenging issue. And as a result, this is decline of water availability between developed countries and developed countries humid and developed countries arid. And it's just going down every year. And we mentioned the large number of international watercourses, about 300 rivers, 100 lakes, and about 300 aquifers, shared by 2 or more states. Many basins are without agreements. You look at some of the major basins, the Congo River, with a huge amount of water, 9 countries sharing it, not a single agreement. You look at the Brahmaputra River, a huge amount of water, 5 countries or fighting over it, no agreement. And when agreements exist, they are not, in most of the cases, they are not inclusive of all the riparians. We look at the Mekong River, shared by 6 countries, only 4 have signed the Mekong Treaty. China and Myanmar have just, sometimes they're called dialogue partners, but they are not signatories or parties to the treaty. Worse than that is that validity of some of the treaties are challenged. There are exist treaties, but some parties are challenging the validity, and that is the main characteristics of a Nile. There is a 1902 treaty between Ethiopia and Britain, which Egypt claims that they have inherited it. There is a 1929 treaty between UK and some of its colonies in East Africa. And now when those colonies became independent in 1960, they said that they are not bound by those treaties. So the entire architecture of the Nile is really centered around the treaties that are Egypt claims their validity, 1929, 1902, and 1929, and the other countries, Ethiopia, Kenya, Uganda, Tanzania, who claim that they are not bound by those treaties. So that's a major challenge. We had no treaty in force until 2014. So for a long time, with all the disputes and all the problems, there was really not much to guide the countries or the tribunals. The UN Convention only entered into force 9 months ago. And so the result is largely unilateral development plans, because everybody for himself, building dams, building irrigation structures. This is just a quick expose of the rivers, main rivers. Danube 16 countries, Rhine 11 countries, Nile 11 countries, Congo 9, Niger 9, Zambezi 8, Amazon 8, Mekong 6, Volta 6, and Jordan 5. And there were a large number of aquifers, which Gabriel will tell us more about when we get into the afternoon, that are shared between 2 or more states. This is the structure, the Danube River, and a large number of countries is in its basin. The Nile River, with 11 countries, or it's in its basin. Quickly, I would go through the evolution of international water law, but I think I'll do it as quickly as I can. And we can look at the state practice and the theory of theories and agreements that developed, the League of Nations conventions, and then the contribution of 2 scholarly non-governmental organizations, the Institute of International Law and the International Law Association. And the large number of case law, the arbitral awards from the Permanent Court of International Justice, International Court of Justice, PCA, Permanent Court of Arbitration cases, and other decisions like the neutral expert and the Indus Waters Treaty. Indus Waters Treaty establishes 3 sets of, 3 layers for resolving dispute. One of them is a neutral expert. And there was a case that went to the neutral expert, the Baglihar Dam between India and Pakistan. And it was written by, the decision was written by an engineer, but largely by contribution from a lawyer. And it raises some interesting legal issues. And then, of course, there is a contribution of the UN and the International Law Commission, which presents itself in the convention. And then there are some post-convention cases that came to the ICJ, the Gapchikovo-Nagemoaris and the pulp mills, which both of them came after the convention and added a lot to the interpretation of the convention. I really don't want to spend much time. I think most of you would know about the state practice, absolute territorial sovereignty, which came from the Harmon Doctrine in the USA, where it was the opinion was that if the river runs into my country, I don't care what happens to other countries. I can do whatever I want. And that, of course, was discredited, and even in the US, nobody believes anymore that this is a theory. And there is absolute territorial integrity, which is largely the opposite, allow the river to go to that countries without touching it or without, again, it's not a reasonable theory. And then as a result of the two, the theory of limited territorial sovereignty or limited territorial integrity developed, which is basically restricting both principles and coming out with the reasonable equitable utilization and no harm together, but that's again easy to say than to put in practice. And then there is a community of riparian states, which we mentioned earlier, that the river is really a joint economic property of all the riparians. The Institute of International Law really started the work on the international watercourses earlier than many others, and they issued the Madrid Declaration in 1921. And basically it stated that states may not utilize a watercourse in such a way as to seriously interfere with its utilization by other states. This is basically the no harm doctrine, the no harm obligation. And interesting enough, most of the work of the Institute of International Law developed around the no harm doctrine. You can use the river, but you have no right to harm the others, the other riparians. And they brought some flexibility in the stricter interpretation of that rule in the Salzburg Resolution of 1961, which recognized mild equitable utilization, but still is stuck to the no harm doctrine. And then they had the Athens Resolution and the Salzburg Resolution, 1979 and 1997, which basically dealt more with the quality issues. And then there is a work of the International Law Association, which is run in parallel to the Institute of International Law, and but started a little bit late. The Water Law Committee was established in 1955 by the ILA, and then it's issued the first statement in 1956, the Dubrovnik Statement. And then followed on that almost yearly, New York's resolution, Tokyo 64, and then this all culminated in the famous Helsinki Rules of 1966. And the most comprehensive rules of international water law until the UN Convention was adopted, based on equitable and usable utilization, laying down the factors that now everybody is using or relying on. The seven factors that laid in the Helsinki Convention became the basis for the UN Convention, the groundwater law, the Nile Basin Cooperative Framework Agreement, Zambezi River, many of them just pulled those factors and played around a little bit with them, but they really form the basis for and this is a major contribution of the Helsinki Rules. And they didn't just the rules didn't deal with the issue of navigation uses. They dealt with pollution, navigation. They dealt with timber floating, which was widely used in the 50s and 60s. And then they dealt with prevention and resolution of disputes. The rules were widely accepted. Many of the disputes that came in late 60s and 70s and 80s, both sides would be arguing the Helsinki Rules. I saw the two papers presented to the UN General Assembly by India and Bangladesh on the Ganges River, and each of them claiming whatever water rights they were claiming under the Helsinki Rules. So it was very, very, very widely used. And basically, as many wrote, they represent customary international law. This is a major argument put by a number of leading authors on this issue. The Helsinki Rules were followed by the Montreal Rules and the SOR Rules in 1986, and then all those rules were compiled in the Campioni Consolidation of 1999, and then the ILA issued the famous Berlin Rules in 2004. But I think the 2004 Berlin Rules were overshadowed by the convention. They came at a time when the convention has already been adopted and it was widely being ratified. So they didn't really prove as important or even as relevant as the Helsinki Rules or the UN Convention. A number of cases, as I mentioned, the territorial jurisdiction of the International Commission of the River Order, this is I mentioned earlier, it's a 1929 case. Which decided that any tributary of international river is part of the international river, part of the definition of international river. The Meuse River case, Belgium and France, which basically endorsed in a way the use of equitable and reasonable utilization. Then the Oscar Chin River between UK and Belgium on issue of navigation, the Trail Smelter about the no harm rule, and the Lake Lanu arbitration about notification, which lays down the rules for notification, and then the Corfu Channel between UK and Albania, although it wasn't on international waters, it laid a number of rules that were quite relevant or were and still quite relevant to issue of international watercourses. So those were the pre-1997 convention. And all those tributaries really flow into the work of the International Law Commission and the UN. The UN started working in 1959, about 15 years, almost 14 years after its establishment, passing Resolution 1401, which asked for preliminary studies to determine if the subject of international rivers, and they talked about international rivers at that time, is appropriate for codification. The report was completed in 1963, and what it did was it compiled the list of international rivers in the world and the list of treaties that were signed and ratified until that time, which was quite helpful because that was really the first serious effort to put together all this information. And study was completed in 63, distributed to the countries to look at them, and then that was followed by 7 years later by the UN General Assembly Resolution 2669, which asked the International Law Commission to look into the progressive development and codification of the rules of international law relating to international watercourses. So that was the mandate that was given to the ILC in 1970. The Register of International Rivers was issued in 1977, and then Mar del Plata Water Conference was held in 1977, and both of them really tied the two resolutions, Resolution 1401 and Resolution 2669, because the Register of International Rivers was issued based on the earlier resolution and was used later, and similarly the Mar del Plata Water Conference, which was issued in 1977, which was held in 1977, dealt with the Resolution 1401 and the report, and asked the International Law Commission to keep working and speed up the process of drafting the convention. But that work wasn't easy either. The ILC started working in January. They had the first meeting on January 20th to look into Resolution 269 and the mandate. And they just kept working for 23 years. 23 years, which just shows the difficulties that were there. 5 rapporteurs and 15 reports. Huge amount of work. Finally, they finished in 1994, draft convention submitted to the 6th committee, which was convened as a working group of the whole, meaning all the countries were represented. It met twice, in 1994, and then it distributed the convention to the member states and asked for their views, and then it met again in 1997 in April, and adopted the draft convention, but it issued 9 statements, clarifying some of, called 9 statements of understanding, clarifying some of the provisions of the convention. And finally, May 21, 1997, the General Assembly adopted the resolution approving of the convention. Huge vote, 103 countries for. Only 3 voted against the convention: Burundi, China, and Turkey. And we could see that all of the 3 of them are upper riparians. Turkey is upper riparian for Tigris and Euphrates, China is upper riparian for Mekong, and Burundi is upper riparian for the Nile. So that just shows from the beginning where the countries stood in their interpretation of the convention. 27 countries abstained, and they have a large number of very important countries: India, Pakistan, Egypt, Tanzania, Ethiopia. And the convention was opened for signature on May 20, and it took another 17 years for the convention to enter into force, August 17 last year, 90 days after the deposit of the 35th instrument of ratification by Vietnam. So it's a very lengthy process dating back to 1970. So we literally have 47 years from the day the UN General Assembly passed its resolution to the day the convention entered into force. And many people gave up on the convention because of this lengthy process, but we kept saying, well, it will enter into force when it enters into force. Those are the countries that ratified the convention and the dates. But if you're really interested, Gabriel Zechstein's website, International Water Law Project, has a list in a better way, and and it has also updates. Gabriel updates it, and it's been really great. We're all grateful for the work he has done in that area. Country would ratify in 9 a.m. and 9:05. It will be in Gabriel's website. And this is a division of the countries. Europe, 16 countries are part of the convention: Finland, Norway, Hungary, Sweden, Spain, Netherlands, Portugal, Germany, Greece, France, Italy, Ireland, Britain, Montenegro, Luxembourg, and Denmark. 9 African countries: South Africa, Namibia, Guinea-Bissau, Chad, Burkina Faso, Cote d'Ivoire, Niger, Benin, Nigeria. And 9 Middle Eastern countries: Morocco, Syria, Jordan, Lebanon, Qatar, Iraq, Libya, Tunisia, Palestine. 2 Asian states, Uzbekistan and Vietnam, and none from the Americas. It's a framework convention to be complemented by agreements between the parties. This is a basic characteristic of the convention. It really doesn't lay any there are substantive rules, but it's basically a framework convention. And it aims at ensuring the utilization, development, conservation, management, and protection of international water courses, and promoting optimal and sustainable utilization. So all is a vision and some procedural rules, with very few substantive rules. And it's based largely on the work of the ILA, the International Law Association. If you look at the Helsinki rules and compare them, you'll see a lot of similarities between the Helsinki rules and, of course, development and of the rules. Some of the work of the Institute of International Law, and there are about 7 areas which the convention addressed: definition of watercourse states, and watercourse agreements, what happens to the existing agreements when the watercourse convention enters into force, and then the principle of equitable and reasonable utilization and participation, and the obligation not to cause harm. And we'll see in a minute that this is the relationship between the two has proven a very difficult and very challenging element of the convention. And then the notification for planned measures by the state planning the measures to the other riparian states. And then the environmental protection and preservation and dispute settlements. Those are the basic 7 areas that are addressed by the convention. definitions, the watercourse, a system of surface waters and groundwaters constituting by virtue of their physical relationship a unitary whole and normally flowing into a common terminus. A very difficult definition which excludes fossil aquifers, aquifers that are not connected to rivers or to international rivers, but that was a compromise. That was the only way for the ILC to go ahead with the convention, because many of the countries just said, keep groundwater out of the convention. Don't touch groundwater. It's too difficult. We don't have enough information. Gabriel will say more about this, so I think I will use my time on other areas. But it has proven a very difficult area from day one. And Pakistan abstained because of groundwater. They said they recorded that they will abstain from groundwater. Same thing, India voiced some concerns. Saudi Arabia, Qatar, and Libya. Interesting enough, Qatar and Libya joined the convention later. And they said, well, we have water, which some people think are not connected, but we think they are connected. That's why we are joining. And as mentioned later, Libya thinks and hopes that the Nubian sandstone aquifer, which is shared by Chad, Libya, Sudan, and Egypt, is really connected to the Nile. They are hoping to be part of the Nile. So they voted for the convention and they ratified for it, but we'll come to that later on. A watercourse state, a state party to the present convention, whose territory part of the international watercourse is situated. And then there is talk about regional economic organization, which I think I will leave. I'll not go into details. And then the first issue that the ILC faced was what happens to the existing agreements when the convention entered into force. And there were two schools. The convention should prevail over those agreements. And there was the other's thought, no, it should not. Those are agreements that were signed by the parties. Why are we interfering with them? And there was the mention of the Indus Waters Treaty. 10 years of intensive negotiations between India and Pakistan with the facilitation, good offices of the World Bank, meetings everywhere in the world, 10 years. 2 senior staff fully devoted to working on the Indus Treaty, one of them vice president, and with technical staff. Do you really want all that efforts to be just scrubbed away by the convention? So and I think the ILC dealt with the issue in a very reasonable way. It asked the parties to consider harmonizing such agreement with the convention and allows watercourse state to enter into agreement which apply and adjust the convention. And it goes further, and that is the most logical and interesting part. Partial agreements do not affect rights and obligations of non-parties to such agreements. If India and Pakistan signed the Indus Waters Treaty, China, which is not party to the treaty, the rights are not affected. Or if in the Mekong, the 4 countries signed the treaties, the rights of other countries, and I think that made it really, the provisions very sensible and very reasonable. But it's a compromise which a number of countries on one side didn't accept it, and a number of countries on the other side didn't accept it, and this is one reason for the delay in the ratification process. A number of countries that we talked to, why aren't you signing the convention? Why aren't you becoming part of the convention? They quoted the issue of the existing agreements, that the convention either is not strong enough in dealing with the existing agreement or too strong in dealing with the existing agreements, depending on whom you talk to. The second principle is equitable and reasonable utilization and participation, and this is really the crux of the convention. Watercourse states shall utilize the international watercourse in an equitable and reasonable manner. Watercourse states shall participate in the use of development and protection of the international watercourse in an equitable and reasonable manner, so utilization and participation. And watercourse states shall cooperate on the basis of sovereignty, sovereign equality, territorial integrity, mutual benefit, and good faith. And cooperation is really the cardinal principle of international water law. I would think that, without cooperation, there is really no international water law. It will just be every country for itself, and we'd have all the competition and all the disputes and then the powerful will be more in a better position to utilize the watercourse than the less powerful or the weak. And so you need cooperation, and not only because of this, but because this is the really the most appropriate and efficient use of the watercourse is through cooperation. And we'll come to this in a minute when we talk about the Nile and the Ethiopian dam and how it comes to this. Those are the factors for determining equitable and reasonable utilization. I think most of you are aware of them, so I really don't want to spend time. Geographic, hydrographic conditions, social, economic needs of the watercourse states, population dependent on the watercourse, effects of the use by one state on other states, existing and potential uses. And I think this is where the convention tried, and I think successfully, in linking between the no harm rule and the equitable and reasonable utilization. It says existing and potential uses of the watercourse, which would mean that those existing uses cannot be, they are a factor to be taken into determining the equitable and reasonable utilization. Again, let me take the Nile case, where Egypt uses 86% of the water of the river. 86% of the water of the river. Ethiopia contributes 86% of the waters of the river, and it uses only 1%. So here you have and that's where the Nile dispute comes from. And so if you look at those factors, I think they take into account the interest of both Ethiopia and Egypt. Existing uses, Ethiopia cannot deny Egypt the fact that they have been using the river for 3,000 years. At the same time, Egypt cannot deny the fact that 86% of the river is coming from Ethiopia. And then there is the availability of alternatives of comparable value to a particular planned existing use. And then the weight to be given to each factor is to be determined by the importance by comparison to other factors. I think this article is a very reasonable article in my view. And it is linked to the prevention of significant harm. A riparian state must do its best not to cause significant harm to another riparian state of international watercourse. If despite the best efforts, significant harm is nevertheless caused, it must again do its best in consultation with other riparians involved and having due regard for equitable and reasonable utilization. So the linkages is to equitable and reasonable utilization, and in my view, this is a subordination of the equitable and usable utilization, of the no harm rule to equitable and usable utilization. In other words, the convention is really a convention about equitable and reasonable utilization. And so it links it to the countries have to take into account the equitable and reasonable utilization to eliminate or mitigate such harm and to discuss the issue of compensation, which means that the harm can be dealt with. It is not an absolute prohibition of harm, as the Madrid Declaration of 1921 has mentioned. The obligation of significant harm applies to both quantitative and qualitative aspects. You cannot take much water from the river and you cannot pollute the river. But the most important is the obligation applies to both upstream and downstream riparians. And this is really less understood, not only by engineers, but even by lawyers. And I wrote an article on that issue of that the downstream riparian can also harm upstream riparians. It has been a major debate, and the theory that I tried to put in that article is an downstream riparian can harm. Of course, we understand how an upstream riparian can harm a downstream riparian. If you block the water and build dams like Turkey is doing on the Tigris and Euphrates, you can harm Syria and Iraq. That's understood. But how can the reverse happen? How can Syria and Iraq harm Turkey? They can harm Turkey by, and here the cases of Egypt and Ethiopia, by using more than your share and claiming a historical rights, claiming existing uses. And then you deprive the other riparian states of their equitable and reasonable utilization, and thus you are harming them. And if you are interested, there is an article called, the title is Upstream Riparians Can Also Harm Downstream Riparians. And I called it the concept of foreclosure of future uses. The state forecloses the future uses. And it's published and it's available on my website. We had permission to print it there. And this is that's my position, and I think it has been widely accepted. But we, of course, because of this lack of understanding, we find the upper riparians, countries like Ethiopia, clinging hard to equitable and reasonable utilization, where you have the downstream riparians like Egypt clinging hard to the issue of no harm. But I think the convention dealt with them in a reasonable manner, and I think it has resolved what could be seen as difficulty in resolving it, or contradiction, or as some of the authors like Attila Tanzi called the Gordian knot that is still there. So in my view and the view of many others, and this is the view of ICJ that the convention, the obligation of causing no harm, subordinates the principle of equitable utilization. And this is what was mentioned by ICJ in the Gapchik-Gomorrah's case. So I mentioned that the harm possible by both riparians, by prior use and claiming of the right to such uses by downstream riparian. Mentioned this. And I mentioned the example of Ethiopia and Egypt, downstream riparians, upstream riparians, and the issue of foreclosure of future uses. Because basically what Ethiopia is saying to Egypt, you have foreclosed, by using 86% of the waters of the river, you have foreclosed my future uses, and you have foreclosed my right to an equitable and reasonable utilization. And that's where this, I built this theory. And I think we mentioned all of those issues, the relationship between the two principles. The convention also talks about the relationship between different uses, and it says that the no use enjoys inherent priority over other uses. And the understanding is that the convention was really dealing with navigation, that the navigational uses no longer enjoys inherent priority. But the convention goes further than that. It says in the event of conflict between uses, it is to be resolved with reference to Articles 5, which is equitable and reasonable utilization, and Article 7. But it adds a very important element. Special regard should be given to the requirements of vital human needs. Vital human needs. If I'm using the water for drinking purposes and you're using water for growing sugarcane, who should get the? Who should have the? Which is more important? Which is vital human needs? Is it drinking water or growing sugarcane, which consumes huge amount of water? And I think the convention here has been quite reasonable in highlighting and underscoring the issue of vital human needs. And one can easily argue that this is really a basis for the human right to water under the convention. Then the crux of the convention, the most important element, is the notification of planned measures. This is the longest chapter, about 10 articles, that there should be exchange of information and consultation on planned measures, but there is also the need for notification. And the interesting thing is that just to underscore my theory, the convention doesn't talk about notification by upstream riparians of downstream riparians. No, it does not say that. It says notification by other states, it doesn't say both upstream and downstream. It says notification of other states of planned measures which may have significant adverse effect on them. So it was clear that it applies to both. It is not restricted to one. It talks about the period for reply, the information to be accompanied by data and information, and including the environmental impact assessment. Specify the period for reply, the obligation during this period, the reply to notification, what happens in there is no reply, an absence of reply, or there is an objection. And the procedure is the in absence of notification. And then talk about if there's an objection and how to be resolved. And this is linked to the article on dispute settlement. And then it talks about indirect procedures. And that came as a result of our work in the World Bank when we talked with the ILC. We told them that when some of the notifications that we asked the countries to do, they would come and say, "Oh, we don't talk to country A or country B. There is no the relationship between us are too bad. They did not notify us before, so we are not going to notify them." And the World Bank developed a procedure whereby it would notify on behalf of that state. So if the state tells the bank, "I don't want to notify, but I don't care if you notify, I'm not objecting," then the bank would jump in. There was a lengthy discussion. If the state says, "No, I'm not notifying and I'm not allowing you to notify," what do you do? It was decided that we will not, the World Bank would not go ahead with the project because the notification is a cardinal principle of international law. So most of them would say, they would not say, "We are not allowing you to notify." We say, "We don't care if you notify. If you want to notify them, that's your decision, that's your judgment, but we don't." So the World Bank started to notify on behalf of that country. We mentioned it to ILC, and the ILC added Article 30 about indirect procedures, which says if there are problems between the states, then the state planning the project can do notifications through indirect procedures through a third party or the UN or agencies. And that's based on our experience. As we have seen in the ICJ case in Argentina and Uruguay, the issue of notification was dealt with very extensively, and those principles were endorsed. The environmental provisions, 4 articles, obligation to protect and preserve the ecosystem of the international watercourse. It's a very broad article, and it involves the ecosystem or the whole, not the river or the watercourse or the lake. It's unqualified obligation, and there is no requirement for collective action. And this is one of the areas where some of the critics of the convention highlight and underscores that the need for collective action is weak in the convention. There is no requirement for establishing a commission. There is no requirement. They urge the parties to establish a commission. They urge the parties to follow collective action, but there is no requirement. And I think that we have to take it in the context of the 1970s and 80s, where if the convention were to go that far, it would have been rejected by, not rejected, by ignored by many states. The second obligation in the environmental provisions is the obligation to prevent, reduce, and control pollution of international watercourse, which may have significant harm to other watercourses. The defines pollution is the same definition as the law of the sea. It requires consultation on measures to prevent pollution, but it's a qualified obligation which may cause significant harm. Again, there is no requirement for collective action. The third obligation is obligation to take measures to prevent introduction of alien or new species which may have effects detrimental to the ecosystem. And it's a very interesting article because we have the experience in Lake Victoria, where a certain kind of fish was introduced in the lake, which eliminated 90% of the other fish. And this is a case where an alien or new species which had really detrimental effect on the fisheries of the Lake Victoria. And the fourth and last obligation in the environmental provision is obligation to take measures to protect and preserve the marine environment. And here the law of the sea and the law of fresh waters interact and get linked. It requires taking account of generally accepted international standards and rules, and that's basically the reference to the Law of the Sea Convention. No requirements again for collective action, but extend possibility of cooperation to non-watercourse states because of the linkages and connection. And the four articles on the environmental provision really impose due diligence standards. Resolution of dispute, this is the last article, the last chapter of the book, of the convention. It asks the parties to negotiate and use the diplomatic routes or the joint mechanism. And it's interesting that the convention here is talking about the joint mechanism between the riparian states, but it does not oblige the states to establish a joint mechanism. So there is some of the people who wrote about it thought this is a contradiction. It's not a contradiction, but it is not it's not as clear and streamlined as one would expect. And then it talks about the good offices, mediation, conciliation by a third party. And this is an example of the World Bank Indus Waters Treaty. And then about impartial fact-finding. And this is the only, it lays down detailed rules for fact-finding commission. And then the report to be considered by the parties in good faith. To be considered by this is the only obligatory part of the dispute settlement and the convention. All the others are suggestions to the parties to take the case to the International Court of Justice or to refer the dispute to arbitration. But the only requirement is the impartial fact-finding. And it's interesting to see how the countries reacted to that. China said we are voting against the convention because it imposes one way of resolving the dispute. Other countries said we are voting against the convention because the dispute settlement mechanisms are very weak. So you have this those two contradicting views on the dispute settlement provisions of the convention, and this just takes us back to the earlier debate about the existing agreements or the debate on equitable and reasonable utilization. And I think it's a reasonable way of resolving the issue, just the impartial fact-finding and its report and requirement to be considered in good faith. And this is what the World Bank does. If there is a one project in one country and there is an objection, 10 minutes, okay. There is an objection, then the bank would form a fact-finding commission. Okay, this takes me, I probably will take less than 10 minutes, to the last part of my presentation, why should enter into force of the UN Watercourses Convention matter. I would start with the fourth point in this. We have been told by particularly some of our environmentalist friends in some of their writings that before the convention entered into force, water is the only major resource that has no treaty regulating its uses. This has been kept, we have heard it a lot as if it is a criticism of those of us working exclusively on water. And that criticism is over. Now we have a treaty. Now we are no water resource, shared water resources are no longer resource without a treaty regulating their uses. I think that's a very important achievement that now there is a convention. But why should it matter? Endorsement by the ICJ. In both cases, the captive Morris and the pulp mills. And what is interesting here is that when the ICJ endorsed the convention in both cases, none of the four parties to the disputes were parties to the convention. The first time, Hungary and Slovakia, that was in 1997, neither of them was a party. Hungary joined later in 2000. And then the latter case, Argentina and Uruguay, neither of them is still our party. Neither of them is a part of the convention. So you have an ICJ telling the parties that are not, the four parties that are not parties to the dispute, whatever you tell me, there is a convention. And I think this is a major endorsement, legal and factual. Second or third point, a number of regional and bilateral treaties adopted UN Watercourses Convention. Southern African Development Community Protocol on Shared Watercourses was issued in 1995, and then they revised it in 2000 and reissued it basically to really reiterate the provisions of the convention. We have the Mekong rules on notification, which are really reiteration of the notification rules under the convention. We have the Lake Victoria Protocol, the Nile Basin Cooperative Framework Agreement. All of them are based on the convention. And the endorsement by a number of global institutions. The ILA endorsed the convention, although they later on worked on the Berlin rules. The World Water Council endorsed it. The World Commission on Dams had a very strong endorsement of the convention. So that should really make it matter. The basic principle, and this is a legal argument, the basic principle of the UN Watercourses Convention reflect customary international law. Equitable and reasonable utilization, as we have been saying in the last hour, obligation against harm and the linkages between the two, the requirement of notification, the environmental protection, the peaceful settlement of disputes, those are all established customary international law principles. So what the convention has done is really just to codify them. And the legal effects and relevance go beyond the 36 because of this. And because of what the ICJ did in Hungary and Slovakia case and Uruguay, the legal effects and relevance of the convention will definitely and has already gone beyond the 36 parties that have ratified the convention, and it will extend to all states. So I think that should make a big difference, that this is whether you are a party to the convention or not. If there is a case before international tribunals, the tribunal will apply the rules of the UN Watercourses Convention. It confirms the primacy of equitable and reasonable utilization over the obligation not to cause harm. I think that's a very important clarification of the two basic principles and resolution of the Gordian knot. And there is now a treaty for judicial and arbitral tribunals in disputes. There is no doubt that any tribunal, PCA or regional tribunal, or the ICJ, whenever they have a case before them, they will refer to the convention. That takes me to the last slide, and I don't think I will to be less than 10 minutes. International water law is a law of cooperation, and cooperate is mentioned 15 times in the convention. If you look at the convention and just use the word search for cooperate or cooperation, you'll find it 15 times. It is still dominated by misconceptions, which we talked about basic principles, existing agreements, equitable and reasonable utilization, and the obligation not to cause harm, and the dispute settlement. And some talk about the environmental provisions are weak, but still, that was the art of the possible. That was the only thing that could be achieved with all the divergent views on those issues. There is the issue of sovereignty, which some countries still talk about, sovereignty over water courses or natural resources, which some countries still talk about. But finally, and the last sentence, that entry into force of the UN Convention is a major landmark in the history of international water courses. I think there is no doubt about it, and it's a codification of customary international law, and the basic principles are binding on all states, whether they are party to the convention or not. Thank you very much. This is my website, if you are looking for any of some of my work, Salman M.A, www.salmanmasalman.org. Some of the articles I mentioned are there.
Thank you very, very much, Salman. That was a fascinating journey that took us to today, 2015. The Watercourses Convention is in force. Does it matter? Obviously, yes. But I'd like to now open it to the floor for some discussion. We have time until 12, so there's plenty of time. What I would like to kindly ask you when you do get the floor, if you could just introduce yourself to Salman with your name, affiliation, and also wait for me or somebody else to give you the mic. So.
Hi, I'm Stephanie Hawkins. I'm a PhD researcher at the Strathclyde Centre of Environmental Law and Governance. I have a question about Article 6 of the Watercourses Convention and the fact that weight should be given to each factor in accordance to the other relevant factors. And I wanted to ask how you've seen this work out in practice and how you've seen it being applied by states, and whether there are some factors which take priority over others in the actual application of that principle.
Thank you.
The best case I can talk about is the negotiations between India and Bangladesh on the Ganges River. They had series of agreements which were all short terms, 3 years, 2 years, and they were hoping to get, that was in the 70s, from the 70s, after Bangladesh became an independent country. One of the major issues was the Ganges River. The Ganges River comes in a huge amount of water in May, June, July, August, September. About 90% of the water comes in, and it just floods Bangladesh. And every year, hundreds of thousands of people are flooded. And then comes January, February, there isn't any water coming. You can just cross that huge, mighty river from one bank to another bank walking. And so there was an issue of Bangladesh. They were blaming India. When there is a lot of water, you just open all the gates and let it drown us. When there is less water, you close all the gates and we get nothing. And so they had series of agreements. The beginning, India was more friendly to Bangladesh, so they were willing to give them something. But then later on, the issue became very difficult. And they sat down, and again, the World Bank played a minor role. And the issue was really based on those. At that time, the UN Convention hasn't been adopted. It was in the last agreement was 95, just before the agreement was adopted. But we looked at the Helsinki rules, and we start looking and talking to them about how many of the population of each country relies on the river, what are the existing uses in India, what are the existing uses. So they have been used. And I think the agreement finally that was signed in 1996 between India and Bangladesh was heavily reliant on those factors. I think the US, the US-Mexico agreements were also, they used, you look at SCELG's book, they used those factors, but I don't know the details, I'm not aware of them. But that was the best example of sitting down. Now, and just in the last 4 or 5 months, when the agreement between Ethiopia and Egypt and Sudan was signed on the Grand Ethiopian Renaissance Dam, they start talking about equitable and reasonable utilization. And that was raised by Ethiopia, and for the first time, Sudan and Egypt were willing to discuss the concept of equitable and reasonable utilization. And Ethiopia was saying, oh, well, my equitable and reasonable utilization is not consumptive. I'm using the water for generating electricity. And the agreement that was signed in March 23rd between the 3 countries refers specifically to equitable and reasonable utilization of the river. So I think it is emerging, it is there, it has always been there in the minds of the states, but in most recent cases, it was effectuated, it was put into effect, and it will continue to be put in effect.
I know there are more questions, but I was actually going to ask you, Salman, about the GERD, the Great Ethiopian Renaissance Dam. So here we have a planned activity between Nile countries. My question is, and you partly answered it, but has the entry into force of the Watercourses Convention played any role whatsoever in the fact that these 4 countries now actually have signed this agreement? When was it? On the 23rd of
March.
Does it matter in that sense?
That's a very interesting question. And actually, I did write an article in Arabic about the entry into force of the UN Convention and what I called its indirect impact on the thinking of the Egypt, Sudan, and Ethiopia. I think when the Ethiopians decided to build this dam, of course, there is a hegemony of the Nile. You have to say it. I'm from Sudan, but Sudan and Egypt have been the hegemonist. The 86% of the water is used by Egypt, 13% is used by Sudan, 1% goes into the Mediterranean, if it gets there. Sometimes Ethiopia uses a little bit of it. So 2 countries signed an agreement in 1959, a very unfair agreement, which basically divided the water between them and ignored the others. They said the Nile has 84 billion cubic meters in Aswan, 10 billion goes into evaporation in the Aswan High Dam. The reservoir of the Aswan High Dam is called Lake Nasser. 74 billion are left. Egypt gets 55.5, Sudan gets 17.5. What do the others get? That's their problem. It was very unfair, and I called it in my Arabic writing a very, just more than unfair. And so the countries became independent. Ethiopia was already independent, and they started claiming their rights under the Nile. And then what did Egypt and Sudan say? Oh, you cannot touch our existing rights. No harm obligation. There is a rule under international law which prevents you from harming us. So if you take one bottle of water, that will affect us. So you cannot touch it. And this is a classic case of the two doctrines, equitable and reasonable utilization and the no harm getting into their conflict. So the situation continued like this, but of course it was fed by the power of Egypt. Egypt was the most powerful country in the region. It has very close ties with the West, so there is no country can get financing for any of its projects unless Egypt says so. And so the Ethiopians waited and waited, and when Egypt got into its internal turmoil by the January revolution, realized, okay, it's time for us to jump in the Nile. And the revolution started on January 25th. Hosni Mubarak, the former president, was toppled, and he resigned in late February 2011. And in March 2011, Ethiopia announced to the world that they are building the Grand Ethiopian Renaissance Dam. Just about few weeks from, Egypt was really engulfed in this internal turmoil. And then Egypt said, no, you cannot build a dam because there is a 1900 treaty which requires you to notify us, and it gives us a veto power. And Ethiopia said, nonsense. I told you a million times that treaty is not binding on me, and I wrote to you, I wrote to the UN, I wrote to the African Union, and it's not binding on me. So the problem started, and then on the issue of equitable and reasonable utilization, Ethiopia is saying, this is I'm using it for my equitable and reasonable utilization. Egypt is claiming the no harm, Sudan. I'm sorry, Egypt and Sudan, clinging to the no harm rule. And then the issue of notification. You have to notify us under international law. And Ethiopia said, well, you never notified me of any of your projects. Why should I notify you? You build the High Dam, you build Roseris Dam in Sudan, you build Marawi Dam in Sudan, you build the Toshka scheme, you build the canal, the Peace Canal. You never notified me. Why should I notify you? It's a two-way street. One of your lawyers wrote about this. Salman wrote about it. Why don't you go and read his article? So the issue of notification and the issue of equitable and reasonable utilization, I think gradually under the pressure of the world, and then the entry into force of the UN Convention. I think that was in August. In August, when and that was your question, when the convention entered into force, and the whole world I wrote about it in Arabic in a number of articles, and of course the Egyptians were following it, Sudanese were following it, the Ethiopians were following it, although none of them is a party. Then I think it added to the pressures. It is not the only reason, and it's not the only source of pressure, but it added to the pressure. Now there is a treaty, and the treaty is equitable and reasonable utilization, resolution of disputes through peaceful means, and I think it really played a major role. And immediately after the convention entered into force, President Sisi of Egypt and Prime Minister Haile Mariam met in Malabo in the UN, in the African Union conference, and that was when they agreed that, okay, we will work out. You have the dam, but you have to look into the issues of the period for filling it, the issue of its safety, the issue of the power trade, and the issue of the future relations. And I believe firmly that the entry into force of the UN Convention played a major role into, not the only role, but a major role into convincing Egypt and Sudan, look, the global architecture of international watercourses has changed after the convention. You cannot talk about power, you cannot talk about destroying the dam and bombing it. There are new factors and new realities, and you have to live with them, and you have to adapt them and adopt to them.
Thank you. I know Juan Carlos has a question. Yes.
Thank you, Dr. Salman. So, again, my name is Juan Carlos Sanchez, PhD from the University of Dundee. It's not even working.
We can pretend it's working.
So the question is whether, there's two questions.
Focus on line.
Okay, thank you very much. So there's two questions. One's very short one. I was curious to know where you got the figure of about 300 international river basins. I know there's a little bit of confusion whether it's 263, 276, 292. This is the first one that I see over 300. So I was just curious to know where you got that figure from. And the second one is if you would be advising two riparians that are developing a new treaty for their shared water resources, what type of provisions, aside from the ones that you find in the convention, would you advise them to include? So meaning, what type of major gaps do you see in international water law as it stands in the convention?
Okay, thanks, Juan. The first question, where did I get the figure of 300? All those figures are really approximation. I mean, if you look at some of the figures that were prepared earlier by Peter Gleck and some of the people who worked in this early, late 90s, you would wonder how would you, for example, you look at the Ganges River, and there are many streams coming in. Which one would you consider the Ganges as one river, or would you look at the Yamuna and look at all those rivers? How would you consider it? If you look at the Nile, you have the Blue Nile and you have the White Nile. Would you consider the Nile as one river or two rivers? And then you have the Sobat River. And then you look at the Brahmaputra. You have the same issues. So I think whatever figure, whether 300 or 260 or all will be approximation and will depend on what methodology you use. The 300 figure came from the World Bank studies. And they decided in that study, we would look at the major tributaries, not any tributary. In the Nile, we would consider the Nile as two, White Nile and the Blue Nile. We would not look at the Sobat River as a separate river, or Rahad and Dindir, because those are minor. In the Ganges, I think they considered 4 or 5, Yamuna and some of them. So it really, it's a difficult question, and it depends, as I said, on the methodology. So, and even the World Bank said about 300. They didn't say 300, because again, the methodology is subject to debate. So it really depends, but I mean, I can refer you to that study, but it says about 300 rivers, and I don't think anyone would get the exact figure, because, as I said, how do you look at them? How do you look at the tributaries, and which tributary qualifies to be considered as a separate river, and which tributary does not qualify and can be ignored? So it's a tough question. On the second point about what do I see as the major shortcomings of the convention, if that I understand I think the major shortcoming of the convention is the lack of obligation to establish a commission inclusive of all the parties. I think that's a major difficulty and a major shortcoming of the convention, because experience has shown that those commissions play and have played and can play major roles. If you look at the Mekong Commission, although it's not inclusive, it has been playing a major role. The Niger River Commission is inclusive of all the 9 countries. And look at the European, the Danube, the Rhine, the Amazon. And we spoke to Stephen McCaffrey came to the World Bank a couple of times, and we mentioned this fact. And he said, look, it could be a make it or break it. If many countries don't want to be obliged to be parties of so we will urge them rather than require them to establish commission. But looking at it now, and as I mentioned, the convention itself may appear as contradictory when it talks about dispute settlement and saying using the joint commission. But you didn't tell me to establish a joint commission. You urged me to establish it, but they're using it. And in the Indus Commission, although it's not really total, you cannot qualify it, characterize it as a legal entity. A commission consisting of 2 commissioners, one from Pakistan and one from India. They meet every certain period. They don't have headquarters. They don't have a legal status, but they have played a major role in resolving a lot of disputes. And of course, there are 2 disputes that went to international bodies: the Baglihar that went to neutral expert, and the Kishiganga, which they went to the Court of Arbitration under the Indus Commission, which was administered by the PCA. Mara can tell us more about it because she has written a lot about that. And still, there were a number of disputes, a number of issues that came up in the last 60 years when the treaty was signed that were resolved by those two men and their staff. And so much so that during the second war between India and Pakistan in 1965, the war was going on. There was a certain payment that was due to India, that was due to Pakistan from India. What happened in the treaty, a very complex treaty, 150 pages treaty, one of the provisions provide for India to pay a certain amount of money for replacement works to Pakistan, because the existing works would go to India. And Pakistan has to construct works to get its share of the water from the rivers that were allocated to it. And the question, who would pay for this, those replacement works? That was a major issue which took 2 years to resolve. The World Bank put some money at the concessional terms. There were donations from UK, from Australia, from New Zealand, from Germany. And then there was 90 million from India to Pakistan, $90 million, because they were inheriting the existing works, so to replace them. During the war, there was a payment due, and the Commission made sure that the payment went from India to Pakistan. It was because the Commission was existing, and it made sure that despite the war and the killing between the two parties, that the Commission went ahead. So I think it's a major problem for and if I were to revise it now, I would concentrate on issue of establishing a joint, an inclusive commission for every. I would make it a requirement.
More questions?
Hello, my name is Sheila O'Reilly. I'm from IOD Park, a commercial company in Edinburgh, but I'm also a student here in the Climate Law and Policy LLM. I have 2 questions. One, the issues of no harm. How far does this move? Is this just within the river system itself? Or whether, if you think about issues from Bangladesh and India in relation to brown cloud aerosols which contaminate the glaciers in Nepal, which may lead to more difficulties in terms of river run, would that actually be considered as part of the do no harm issues in terms of upstream, downstream obligations? And the second question relates as to whether or not the obligations that you're mentioning in terms of customary international law may affect, say, the clean development mechanism standards of using national environmental standards, or does it create a much stronger obligation to consider upstream and downstream consequences of clean development mechanism funding for hydropower, particularly in Asia and in states like China? Thank you.
Yeah, okay. Two difficult questions, and I would invite comments or additions or whatever I say, because I don't think I will not claim at all that I know everything. I'm sure there are many of you know far more than I do. On the first question, does the obligation not to cause harm extend just to the water, or it goes beyond the water to the other issues? In reality and in practice, I think it goes beyond the water. It goes to other issues. And I'll give you 2 examples from Sudan, where I'm coming from now, and I just flew last night from when the Ethiopians started building the Grand Ethiopian Renaissance Dam. One of the issues that was raised, many issues that were raised by Sudan was the dam will block the sediments that comes from the Ethiopian highlands, which are used by the farmers. So they're not talking about water, they're talking about soil. The Ethiopian soil that comes in mass, about 200 million tons every year in the rivers that cross Ethiopia into Sudan or into Kenya or into Somalia, the Wabi Shabelle and Juba in Somalia, and the Juba in Kenya, and the Omo River in the Lake Turkana, and then the many rivers at Bara, Tekezi in the north, in the Nile, and Rahadindir and Blue Nile and so on. And the Sudanese were saying, well, okay, but this dam will block the sediments which we are receiving. And then some people said, well, but you are now claiming rights, and acquired rights not only to the water, but to the sediments also. And there was a big debate as to whether does this make sense? I mean, are the Sudanese entitled to everything that the Niles carry? The sediments, the fisheries, well, the water is okay. But so that it generated a lot of debate. And then there were some out of the blues guys appeared and said the brick industry will be killed by the Ger Dam, because the brick industry depends on the sediments, if you're aware of that. Now that we have less sediments or no sediments, the brick industry in Sudan will be wiped out of existence. So those are issues. I mean, those are issues. And of course, the issues of the fisheries, the issues of the change of the rain pattern in the area and the climate change. I mean, there will be a huge lake. 74 billion cubic meters extending for 500 kilometers, which will definitely change the rain pattern in the area. And all those are issues that have to be considered. I don't think the UN Convention, the drafters of the convention, dealt with those issues or even wanted to deal with those issues. They have other difficult issues to deal with, and they just left it in a broad terms, not to cause adverse significant harm. And they use the word significant, and then there's a statement of understanding as to what we mean by what is meant by significant harm. But those are issues that I'm sure will develop as we go from one river to another river, from one dispute to another dispute, from one country to another country. And I'm sure this is an area where there is a lot for the international water law, especially during through tribunals, to look into those issues, especially the issues of fisheries, now the issues of sediments, as I said, the issues of changing the rain pattern of those countries, and there will be many others that will prop up. Now I have to be reminded or refresh my memory about the second question. Quickly, just I know it.
It's to do with whether or not the international obligations created under customary international law may affect the implementation of the clean development mechanism, which is based on national standards and particularly in issues of hydropower investment for climate change mitigation.
Okay, there was an earlier question about what are the areas of weakness of the convention, and I mentioned the issue of the commission. Another area that some of the people who wrote criticizing the convention are the environmental provisions. There are some views that the environmental provisions of the convention are weak, that really they are not up to these current standards, that they don't deal with those issues, and that again may be true. In the sense that this convention was completed in 1994. That is almost more than 20 years now. I mean, one of the issues of the climate change and all those issues came after that. But even if they were there, I think with the problems that the Commission, the IRC, was facing with the other provisions, I don't think they would really have the they would really want to dwell into those complex issues. They will probably leave them to the current discussions that are going on and the Kyoto Protocol and the climate change and leave them. And as I said, this is an area where there is criticism that the convention is weak. But in this area, I think the convention was a compromising document between two different schools of thoughts. And those who have written about the UNECE Convention, Helsinki Convention, mention often that the UNECE Convention has highlighted and underscored more the issues of quality which Europe is facing, whereas the UN Watercourses Convention dealt with the quantity issues which the developing countries are facing, and rightly so, because Europe has its own conventions and treaties, and this convention is really meant for the countries that are facing quantity issues and allocation issues, and that may be true to some extent, and that's probably the reason why difficult issues that you mentioned were not dealt with.
Can I just add something? If you have the microphone. Yeah, Martin Howie, I'm from SEPA. European law kept the IPPC directive and the Industrial Emissions Directive separate from the Water Framework Directive. Yeah. Now, IPPC and IED covered all media. It covered waste to land, it covered, emissions to land, it covered emissions to water, and it covered emissions to air. And one of the principles of PPC IED is that you do not allow transfer of a pollutant from one environment to another. Correct. So if you dredge, you don't then use that dredge material and throw it into to put it next to a watercourse so it goes and resuspends itself back in. Now, I mean, we've got 120 years of laws in this country. I suspect we're one of the most long-standing in the environmental frame. We also have the EU directives piled in on top of that, and then we've got the international conventions on top. So again, you can understand why they wanted to stay clear of it, because when you get the Water Framework Directive and IPC IED at a water treatment works or a wastewater treatment works, you start getting into very, very complex ground.
And muddy areas.
You know, and it's muddy.
No, I agree with you, and I thank you very much for the clarification and the additions.
Yes, first of all, thank you for your talk. My name is Belen Almos Chuponi. I'm a lecturer at law, in law at the University of Stirling. And my question is related to the arguments you mentioned about for why would it matter. And you mentioned the pulp mills case before the ICJ between Argentina and Uruguay. But in that case, there was a bilateral treaty that embodies some of the principles. And then my question would be, according to you, what would have been the difference if, hypothetically, the UN Convention could have been applied to settle the case? That's
yeah. I thank you for the clarification, because the pulp mills case was really based on the treaty between Argentina and Uruguay on the Uruguay River. So I thank you for that clarification. But the ICJ went beyond interpreting the treaty, and actually it linked the two, the provisions of notification under the treaty and the provisions of notification under the convention, and found that they're complement, they're in line with each other, and they're complementing each other, and that's where the endorsement of the UN Convention. I think the ICJ, as one of my colleagues said, I think he said that here at Tanzania, I think on the discussion about, he and I had a lot of discussion on where the UN Convention stands on the issue of equitable and reasonable utilization and the obligation not to cause harm. And he said, the ICJ is biased in your favor. Whenever they get an opportunity, they highlight and endorse and praise the convention. And I think that happened. I mean, you are right, there was a treaty. They could have simply restricted their arguments and their judgment to the treaty. But no, they went ahead of that, and they spoke about customary international law. The treaty is consistent with customary international law in terms of notification. And those principles of customary international law are now reflected in the UN Convention. Your second part of the question, if there was no treaty, I think they would have applied it, and that was what they did with the Gabčíkovo-Nagy-Morris. The convention was adopted in May, and the ICJ issued a decision in September, 4 months, and they went into lengthy discussion about the issue of participation and issue of the basic right of each state to a fair share, which is basically endorsement of the equitable and reasonable utilization. They went out of their way, and one would have thought that the judgment would have been prepared long before the convention was adopted, because the case was lying there for 3 or 4 years in the desks of the judges. But no, it looks like the judgment was written after the convention was adopted when you look at it. So I think yes, definitely the ICJ or any tribunal would have looked at the convention, and they would look at it whether there is treaty or there is no treaty.
From the University of Geneva, many thanks for the presentation. I would like to ask maybe something that could seem not related to what you presented, but what is for you the relationship between the UN Watercourses Convention and the human right to water? Because you mentioned the concept of the vital human needs that for me could be seen as a basis of the human right to water. But what is your view on that topic? And also maybe if you could address a little bit about the relationship between the UN Watercourses Convention and the UNEC Water Convention, that it is now open to all the UN member states. So what is your opinion?
I will start with the last question, which is the relationship between the UN Convention and the UNEC Convention. I thought if this question comes up, I would have asked you to answer it. I would have asked you to answer it. Mara is a senior researcher at the University of Geneva International Water Law Platform, which they carved out of the International Law Department and dealing specifically with international water law. So as a European, as someone working in the University of Geneva, and as someone who has done a lot on the convention, that question should be, but okay. Coming to the first part about the human rights, the human right to water. I'm sure you have seen my book on the human right to water. There is a book, and actually there is an electronic version in my website. And I use the convention. I thought the convention has pushed the concept of human right to water very much forward. I thought the vital human needs is really an important element, important concept. I mean, as I mentioned earlier, obviously if one state is using the water of the river for golf courses and the other country wants it for water for drinking purposes, I don't think any tribunal or any arbitrator would would argue about which use would prevail over the other use. And then it comes to the issues of sugarcane or rice that that consume a lot of water. So I think I don't think there has been enough written about this part of the convention, but I do believe that the convention has added a lot to the issue of the human right to water through that very limited and very short paragraph about vital human needs. If there are any, I think it says if there are any. Basically says if there are the conflicting uses, then preference or priority will be given to vital human needs. So I think that has pushed, but it hasn't been. I don't think enough has been written. And there is a statement of understanding dealing with this issue. So I think it has contributed a lot to the issue of human right to water. On the second part, Gabriel compiled a number of articles on the entry into force of the UN Watercourses Convention. And one of them is written by German lawyer Getz Reichert, who some of you may know, about the relationship between the two conventions. And the question that came from some of the countries that were critical of the convention and critical of the states, I worked with the committee, that ad hoc committee that was put together by WWF, which was headed by our colleague Flavia Lourdes and the Dundee. And we spoke with a number of countries, and some of them were telling us, I don't remember which one was that, look at the list of the countries that ratified the convention. Qatar, what does Qatar have to do with international watercourses? Libya, Morocco, Tunisia. This is a joke. This is what they told us, one of the countries. Those countries have nothing to do with the convention. And then they went further and said, well, 16 countries in Europe. Europe has its own convention. Why do they need to join the UN Watercourses Convention? They have their own convention. They have their own rules. They have their own priorities, which are not addressed in the UN Convention. So this whole process is not serious. I heard this from one country. I would rather not mention the name here. And I don't think that's right. I think Getz Reichert in that article, which is published, it's in Gabriel's website and in website, he argued very vehemently that the two conventions are complementary. The UN Convention is more tilted to the issue of quantity, and the UNEC Convention is more tilted to the issues of quality, and that together they really complement each other and provide clear sets of rules on both issues. And his argument went further and said not all of Europe is concerned only with quality. There are parts of Europe that are concerned with quantity, and that's where the UN Convention would help them. And so I think the argument made by Getz Reichert were very strong and very vehement and very reasonable, that the two conventions do complement each other.
Before I give the floor to somebody else in the audience, if you don't mind, let me add to that. Because you said that one of the hot spots in terms of transboundary waters is in the SADC region between South Africa and Namibia on the Oranje River.
Orange, yeah.
So this is an area I'm very interested in. I've recently been. And one of the things that I see there is that there's actually a lot of activity from the last 15, 20 years. There are a lot of transboundary river agreements. And you have a regional organization, the SADC. So going back to the focus of your presentation, does it matter that the UN Watercourses Convention is in force? Now, my understanding is that both Namibia and South Africa are parties.
Correct.
So it obviously matters. They're both parties to the SADC revised protocol on shared watercourses. And if the Oranje is the Oranje Seku, is it that one?
Yeah,
yes?
yeah,
Okay.
yeah.
We have an Orasicum, we have a treaty. We have a plethora of treaties. We have treaty congestion. You can use whatever name you want. The question to you is, what does the Watercourses Convention add in this specific region or any other region in the world that already has existing treaties? And if I may ask, since you want to bring Mara in, I will ask Mara.
I'm glad you did that.
What does the UNECE Water Convention add to a region like the SADC where you already have existing treaties?
And I don't need this.
Oh, yes,
I think the answer to the first question, and Mara will answer the second one. But the answer to the first question, what is the value added to those regions? First, to take SADC specifically, as I said, SADC has amended its protocol to make it consistent with the UN Convention. So now that, okay, we have the SADC protocol, it's not only consistent, it's actually word by word copied from the UN Convention. So what would the UN Convention add to us? It would add the sense of that there is an international recognition of those principles that I have adopted in my protocol. It's not only me. Those are not peculiar to Namibia and South Africa. The whole world has accepted them, which means that I have made the right decision by adopting them. And actually, I would go further than that and say that the word, as I mentioned, the word cooperation is mentioned 15 times. You can have all the treaties of the world. You can have all the agreements. You can have all the protocols. But if there is no genuine cooperation, then you'd go nowhere. And I made this argument between Sudan and Egypt or Ethiopia when the debate was going on in the Ethiopian Renaissance Dam. And I said, look, guys, this dam should have really been, I've been pro the dam. I thought the dam is good for Sudan, is good for Ethiopia, and it does not harm Egypt. And I've been arguing for the last 4 years on those lines. And I went further and I said, if you guys have really believed in cooperation, you wouldn't need the high dam. You wouldn't need the dams that are built in Sudan and had to forcibly relocate more than 200,000, 250,000 people. You could have just built the Grand Renaissance Dam, which generates far more electricity than the combined Egyptian and Sudanese dams. You could have enough irrigation water for Sudan and Egypt because Ethiopia does not need the water for irrigation. And you didn't need to have all the environmental problems that resulted from the dam and the change of the rain pattern and the fisheries movement and all those problems. But there was no cooperation. And I think what the convention is really built around is the concept of cooperation. And that's being highlighted by all the writings. And okay, you have the treaties, you have the bilateral, multilateral, regional treaties, you have all these agreements. But look, the UN Convention is there, and it's talking about cooperation. It's based everything on cooperation. You need to cooperate to put those treaties into effect and to make a better utilization of the shared water course, whether it's a river or it's a lake.
Salman said about the obligation of cooperation. You say no, the UN Watercourses Convention does not contain the obligation to establish joint commissions. So on the other side, the UNEC Water Convention contains this obligation to establish joint bodies. And it is interesting that two states that are parties to the UN Watercourses Convention, Tunisia and Iraq, are interested in joining the UNEC Water Convention. So in that sense, it can be interesting for them to be part now to the UNEC Water Convention and maybe trying to put into place a joint mechanism with the riparian states.
Yeah, I think, if I may add, just Gabriel, if you allow me 1 second, Iraq, of course, had the larger political architecture. Turkey, all its problem with Turkey on the Tigris and Euphrates. Turkey wants to be part of the UN or part of the European Union. Okay, fine. You want to be part of the European Union? We will join the UNEC Convention, and there we will meet and talk about Tigris and Euphrates. If you don't want to join the UN Convention, we will catch you through the UNEC Convention. And I think that's the larger political dimension to the Tigris-Euphrates dispute between Iraq and Turkey. Sorry, but
finish around 12, so we have time for one question. The others, I hope you don't mind, we'll have in the debate after we conclude. But one question for Gabriel.
Gabriel Eckstein with Texas A&M University School of Law. I'm glad you put this slide on because I've always found this really interesting, and I'm wondering if you have any comments. The pattern of participation. You have a very strong presence from Europe, from Africa, and from the Middle East. Very different regions in terms of economic development, available water resources, and at the same time you have none from the Americas and two from very different parts of Asia. And I don't know if you have any observations about this pattern of membership, of participation in the convention, because I found it very odd. I've tried to rationalize it, and it still seems very odd to me.
Again, I thought this question should be answered by Gabriel himself because he was the one who compiled 9 very well-written and great essays on the regional perspectives on the entry into force of the UN Convention, one from South Asia, one from Europe, one from South America, one from Africa, SADC region, Americas, the Nile. So I thought you are better. But looking at it, I think each of those, it's difficult to really draw an overall pattern. each of those countries have their own differences. Most of the Arab countries, Morocco, I mean, which river would jump into your mind that there is, that Morocco is having a problem is, or Libya, or Qatar, or this, and then when I spoke to some Libyans before Libya fell apart, why are you joining the convention? As I mentioned earlier, they had in mind the Nile. They want to be part of the Nile. And their argument, as I mentioned earlier, the Nubian sandstone aquifer is connected to the Nile. It's not a fossil aquifer. It is replenishable, and it's connected to the Nile. It may add few meters every year, but the concept is there. So you look at all these countries. I asked the Qataris, why did you join the convention? And they said they have problems with Saudi Arabia on the aquifers that is shared with Saudi Arabia. I said, but do you know that this convention does not deal with fossil aquifer? Oh, we know. But your ILC has issued as a resolution saying that the principles of the convention should apply to the non-connected water. And this is non-connected water. So we have something to cling on. There is something that the convention gave us. So you look at those countries and each of them. And you look at Syria and Iraq. Their basic fight their basic thing in mind is Turkey. And that's why Iraq has joined the UNSC convention. That they were one of the few countries. You look at Jordan and the Palestinians. They have Israel in mind. They have the Jordan River and the mountain aquifer and all those. So you look at all those countries, and it really has, it's difficult to draw a pattern. The general pattern that may be drawn is that most of those countries are downstream riparians. And they think that the convention would protect them against the hegemony and the power of upstream riparians. Most of them, not all. You have, because there are downstream, there are upstream riparians in the Nile who didn't join the convention. Tanzania, Kenya, Uganda, Ethiopia, Burundi, Rwanda. I mean, in fact, Burundi voted against the convention. So it's difficult to draw a pattern, but I would say generally, with a little bit of hesitation, that mostly are downstream riparians who think that the convention will protect them against the hegemony and the power of upstream riparians. Of upstream riparians.
Okay, I think we could have a story for every country here.
Yeah.
I mean, to some extent, Britain has no transboundary rivers as far as I'm aware.
I will answer that question. I will answer that question. I was asked by one of the British officials, what is there for us in this convention? Of course, there is Ireland, and there is Ireland. But I gave them an argument, which someone told me later it was accepted. And the argument was, look, you are one of the largest donors through DFID to development projects in the world. And I looked at the records, about 15 to 20% of the money you donate goes to water. And about more than 50% of that water is shared. Don't you think, wouldn't you want some instrument to regulate your work? I know you don't have international rivers, but if you go to the Nile, or if you go to the Niger River, or if you go to Lake Victoria, or if you go to the Mekong, wouldn't you want an instrument to regulate the work, your projects, to be a reference between the parties when they argue? And they said that's, later on I was told that, I mean, there were other arguments, but this argument was accepted by DFID, that, okay, yeah, there is something for us, for our foreign aid.
Okay, before I ask all the floor to thank the Salman, let me first thank the colleagues at the Strathclyde Centre for Interlaw Governance, in particular Stephanie Hawkins, Laura Movilla, and René Martin Negle for their help in organizing this seminar. Also the team within the law school, the admin team who's not here, but they were very, very helpful. Again, the support of the Scottish Government, but most of all, Salman, who flied yesterday to come with us before the World Water Congress, and he'll be with us also this afternoon in other events that we'll organize. So join me in thanking me, Salman.
And thanks again for the invitation. It's really a pleasure and an honor to be here and to spend those 2 hours. I learn as much as probably far more than I give from the questions and from the interactions.